Yesterday, I received a disappointing response to a letter I sent to Attorney-General Symes a number of weeks ago. I'm going to read you the letter, and then I'm going to read a written response that I have. This came in yesterday. Dear Mr. Cartwright, thank you for your recent correspondence to the Attorney-General Jaclyn Symes MP about laws which limit people under guardianship arrangements being able to tell their own story. The Attorney-General has asked me to respond to you on her behalf. I apologise for the delay and thank you for your patience. I acknowledge your ongoing advocacy for the rights of people with disability and you're concerned that these laws may prevent people from sharing their experiences of the guardianship or administration system. I understand your meeting with the Director of Civil Law Policy, name, was very productive and your thoughts have been taken on board as the Department of Justice and Community Safety continues work in this area. As you noted, the Disability Royal Commission, DRC, has made recommendations about how these types of laws should work within the context of a range of recommendations about guardianship systems. Victoria, in consultation with the Commonwealth and other states and territories, is developing a detailed response to the DRC recommendations. I note the federal government is inviting stakeholder feedback on its proposed response, and then they inserted the link to the consultative process that they're going through at the moment. This means that at this stage, any further developments in this area need to be considered as part of this broader project. This helps us avoid any conflicting, confusing or unanticipated outcomes for people with disabilities and their loved ones, as we consider how the recommendations historically apply to Victorian laws. The Victorian government remains committed to supporting the human rights of people with disabilities, including the right to be treated as equals before the law. Your contribution and advocacy have helped to drive reforms in this area. As this work develops, government will continue to engage with stakeholders such as yourself, including as part of the DRC response. Thank you again for taking this time to write to the Attorney-General. Yours sincerely, Acting Secretary of Courts, Civil and Criminal Law. Now, I've written a response and I'm going to read it. As part of my campaign, I've reached out to the Attorney-General multiple times to open up discussion regarding Victoria's gag law, Clause 37 of Schedule 1 of the VCAT Act, which prevents people with disability from speaking out about their experiences. During my campaign, I have gained the support of the Victorian Advocacy League for Individuals with Disability, VALID, the Office of the Public Advocate, OPA, Life Without Barriers, Yooralla. These organisations are committed to upholding the human rights of people with disabilities on guardianship and administration orders. The human rights issue is in the hands of the Victorian Attorney-General. This was made clear to me by the Federal Attorney-General Mark Dreyfus KC MP when I reached out to discuss the issue. He advised that, quote, states and territories are responsible for the confidentiality legislation. These matters fall within the responsibility of the state where the conduct occurred. In your case, Victoria. You may wish to bring your concerns to the attention of the Attorney-General of Victoria, the Hon Jaclyn Symes MLC. End quote. Mid last year, following multiple communications with the Office of the Attorney-General Symes, I met with the Director of Civil Policy at the Department of Justice to begin the important discussion. At that time, I felt the meeting was productive and I hoped it would create an ongoing opportunity to work with the Attorney-General's Office on reform. I was worried the meeting would be tokenistic, but had hoped it wasn't going to turn out like that. This letter, however, has confirmed my fears. This response is an example of how the government's commitment to the UNCRPD to co-design and valuing lived experience continues to feel tokenistic for people with disability, giving me the opportunity to contribute to the federal government's consultative paper regarding the Disability Royal Commission is not an accessible option. This again allows decision makers to avoid having our voices at the table and coming face to face with the people affected by these policies. Throughout the campaign, I've been met with responses like the one below, seamlessly using the Disability Royal Commission process as a way of avoiding making changes to the unjust gag law. To me, having to wait on reform to a breach of human rights that impacts so many Victorians is a sign of how little people with disability are valued in our society. The Disability Royal Commission recommendations cannot be implemented if our most vulnerable cannot tell their own stories. Reforming the gag laws across Australia is a critical first step. As someone who has lived experience under this patronising law, I know firsthand what it's like to have your voice silenced. When my gag order was revoked, I made it my mission to fight for those who have been told their voices are not worthy or being listened to. I will continue to expose and fight the injustices of this law until the Attorney-General takes my voice seriously. Please join us.